Good afternoon, everybody. Good afternoon, everybody. Good morning, good evening, depending on where you're located. Can you hear me? So welcome to this session, everybody. I'll start by, my name is David Wambua. I'm the head of marketing at Ncia. And I'll begin the session by introducing our moderator this afternoon. Our moderator is James Moruthi Kihara. James is the managing partner of Kihara and Wine Advocates. He has represented corporate clients in complex litigations and arbitrations. He's a former chairman of the statutory tribunal known as the Petitions Committee, and he's also a former chairman of the Chartered Institute of Arbitrators, Kenya branch. He regularly writes and speaks at conferences on arbitration and the public-private partnerships. He serves on several boards, both public and private, including our board at NCIA. James holds a master's degree in law and is also a chartered arbitrator and a certified PPP specialist. So without further ado, James, karibu.
Thank you very much, David, and good afternoon, good morning to everybody. Welcome to this session, which I hope is going to be very lively and we'll be able to interact. I have three speakers with me today, and I'm going to quickly introduce them so that we can get going. I will introduce, the first person I will introduce is Lawrence Murrow. Maybe you can wave Lawrence so that we know who you are. His name is there. Lawrence is the current registrar or CEO, you may say so, of the Nairobi Center for International Arbitration here in Nairobi. He is also an arbitrator and accredited mediator, and is a member of the International Council for Commercial Arbitration, and is a member of the Kenya's representatives to the UNISTRO Working Group 2 on Arbitration and Conciliation, and Working Group 3 on Online Dispute Resolution, amongst other appointments. Then I will also introduce Jacqueline Oyuyo Gedinji. Jacqueline is the managing partner at the law firm of Umsizi LLP that is based here in Nairobi, Kenya, and she has gained considerable experience in commercial law practice in close to 20 years practice. She is a chartered arbitrator and a certified court-accredited mediator, and she holds an MBA in global technology management. Jacqueline serves as a director on various boards, including the Nairobi Center for International Arbitration. The third speaker I'll introduce today is David Jugunan Njoroge. David is an ADR practitioner. and is an accredited mediator and an arbitrator of an arbitrator who is a fellow of the Chartered Institute of Arbitrators. David is a member of the State Corporations Appeals Tribunal and is also a member of the National Steering Committee for the formulation of the ADR policy appointed by the Honorable Attorney General of Kenya. David is the senior partner at Juguna and Juguna Advocates, where he heads the Dispute Resolution Department. David is a former council member of the Law Society of Kenya and the East African Law Society. Welcome, panelists. Now, without much ado, I think we'll go straight to today's discussion. And probably I'll start with David. Now, David, we have, of course, we have members of the Law Society of Kenya and other members and other stakeholders who may have joined us. I would want you to introduce today's webinar by telling us what is arbitration, and maybe probably you can contrast it with the litigation. Welcome, David.
Thank you very much, moderator. Ladies and gentlemen, good afternoon, good morning, good evening from wherever you are tuning in from. It's a pleasure to be here and to be seated with such an able panelist. Yes, what do we understand by arbitration? About 8-10 years ago, when I was taught what arbitration and ADR is, I was told arbitration is basically when you hire a private judge. You settle that you want your dispute to be resolved by David, and you come to me, and we sit together and we agree. Where does it come from? Article 159 of the Constitution, 159(2)(c), provides the avenue, and this is the mother of ADR in this country. It talks about that there are various mechanisms other than the judicial system. There are other mechanisms that are available for the resolution of disputes. And it actually mandates the judiciary to promote such alternatives. And this includes arbitration, mediation, conciliation, adjudication, and or even TDRM's traditional dispute mechanisms. So after that, we now have it placed in the grand norm, that is the Constitution. Before even the Constitution, arbitration is not a new thing. It has been here. It has been here with us for quite a while. We have an Arbitration Act of 1995. And in the Arbitration Act, it basically defines what arbitration is. And it says arbitration is basically that which is administered by an institution and that which is not. What does that mean? Arbitration can take two angles. It can be ad hoc whereby parties privately decide that who will be their arbitrator, or they have an appointing authority, for example, Ncia, LSK, Chartered Institute of Arbitrators as the appointing authority. Once the appointment is done, then the arbitrator proceeds and does the proceedings on his own. Contrasting it with institutional arbitration is whereby there is an institute, like, for example, the center, the Ncia, that administers the arbitration. Administration means it offers support. So once there is a dispute, it is referred to the center. The center has a panel of arbitrators that it looking at the dispute and the competency of the various arbitrators in the panel. Then it appoints for you the arbitrator, and it does not leave you at that point. It works with you until the conclusion of that. There is a great advantage into that. Today, there are a lot of complaints due to arbitrators who are ad hoc, and basically they are not conforming and to the ideals of arbitration, especially to the expediency of the arbitration. So whenever you have an institutional based, it will ensure that the arbitration is driven as per the ideals of what arbitration is. So contrasting arbitration and litigation. Litigation, of course, you know, it is the aspect of taking your dispute to court. One great advantage of arbitration is arbitration. Party autonomy is where basically the parties have the liberty and the freedom to choose their arbitrator, to choose the rules that will govern them, to choose the law that will govern them, and basically to ensure that everything that will be decided will be driven from what they agree. Of course, contrasting it with litigation, once you file your case in court, you do not even know, but it will be allocated and will be determined as according to the procedures of the court. The issue of expediency is another great advantage that we have in arbitration. Arbitration, once you lodge your matter, then it can take a consistent proceeding. Comparing it with the courts, of course, you will know the issues to do with backlog of cases and what the delays that we have in the judiciary. And you are expected, I remember, for example, currently the judiciary is dealing with and giving priority to 5-year-plus cases. Those are the cases that are being now had on a priority basis. So you can imagine that is way back in 2016. I can assure you that it will be very difficult for you to find an alive arbitration that is dating back in 2016. So there is great advantage in terms of arbitration and expediency. The other thing that is quite appealing about arbitration is the privacy of the nature. In court, it is public court, and once it is filed, it is open court. Any member of public can peruse that file, can go and hear the case, and at the determination, it will be reported and it will be public domain. In arbitration, it is private proceedings. And once we start off the arbitration, we only allow those who are party to or are connected to the arbitration. So there is great advantage, and we can see a lot of multinational companies and such who want to maintain some business relation and ensure the resolution of their dispute in an expedient manner, choosing the way of arbitration. Comparing arbitration with other ADR mechanisms, we have mediation. Mediation basically is whereby a mediator comes to facilitate the parties to resolve their own dispute. So the mediator will not impose, will not make a determination, will not make an award, but will only facilitate the parties to reach a resolution. Conciliation, on the other hand, is basically a mediator, but with an added role of proposing a compromise at the end. Once you hear the parties and you feel upon facilitating that there is a way that the dispute can be resolved, the conciliator has that power. Then we have expert determination, we have adjudication, which are mostly used in construction, and their time bound 28 days, a resolution date. So in a nutshell, what arbitration is about is basically when parties have a dispute, and the genesis must be from the contract, the agreement that you entered into. Did you put an arbitration clause? I know Jackie will come and talk about how to put the ADR clauses and the arbitration clauses, but that is the authority. Without that authority, without that clause, then as an arbitrator, I do not have the jurisdiction and I do not have the competency to determine the matter. So it starts right from when the parties come to your office as an advocate, as a litigant, as a party out there. It is important nowadays, and it is advisable that you put an ADR clause, an arbitration clause, to ensure that when that dispute comes, then there is that avenue of resolving the matter out of court and doing it by way of arbitration. The other thing that I want to talk about is the link between the center and LSK. I know, again, the registrar, Lawrence, will give more details to this, but I'm a member of the LSK Adr committee, and recently, within this year, we signed an MOU with the Nairobi Center for International Arbitration in terms of collaborations. And I just want to highlight the importance of this MOU, because it will be quite a game changer. And it is important that we as members, the lawyers, and the public at large, to get to know that actually these provisions are now available for us to use. The first aspect of the MOU is talking about collaboration in terms of policy and legal reform. And about policy is basically the LSK, we have that legal and technical knowledge about how to go about the ADR system. So if at all there is any ADR policies, laws, and everything coming across, then the center and the LSK have an understanding that they can be putting heads together and come up with proposals as to what are the best practices so that we can lead from the front in terms of ADR aspects in this country. The second one is the training facilities and the hearing facilities. I would encourage you to visit the NCIA. It has very, very state-of-the-art facilities that can be used by LSK members. If you have a dispute and you have opted the ADR mechanisms, this MOU is now giving us a platform that we can use the facilities of NCIA, of course, at an agreed subsidized rate, and you can resolve your disputes amicably. And the third one is sharing of the panelists. And this is basically the panel of the ADR practitioners, ranging from arbitrators, mediators, conciliators, and all that. We know very well that LSK is an appointing authority, and mostly it has been practicing what I had defined as an ad hoc arbitration. This is an opportunity that now LSK can not only do ad hoc, but can also offer the opportunity for members to choose to institutional-based arbitration by partnering with NCIA, and also sharing of the list. Since LSK has its own list and NCIA has, they can always be sharing to ensure that the best and the competent arbitrators and mediators are appointed at any given time. Then we have the institutional administration, what I had mentioned. And the benefit of institutional-based arbitration is that your arbitration will be monitored by NCIA from the initial time until the penultimate stage of release of the award. So this is a big plus, and it will ensure, even as we represent our clients in these various arbitrations and ADR options, we have somebody, we have an overarching body that will be looking and ensuring that the technical, the support, and the administrative support will be there throughout. And then also there's also issue of promotion of ADR. In LSK, remember, under Section 4, we have a mandate to advise the government in terms of policy, legislative, and otherwise. So we know that ADR has taken center stage in this country, and LSK is quite a big stakeholder in terms of being the body for the lawyers. So the NCIA partnership will usher in a new era whereby we will see our members being the champions of ADR and having that expertise after exchanging ADR to the next level. Use of their different websites and their different mechanisms of reaching out to the public will be of great use. The other one is recognition and accreditation. We know that NCIA is also a training body. So these facilities can also be afforded at a subsidized rate to the LSK membership. So to me, this is quite a big step. It's something that we had been working on for quite some time, and we are quite privileged and happy that it came to pass. And now we have the MOU in place, and as LSK members, we can be able to use the facilities and the expertise of NCIA to ensure that we serve our clients better. As dispute resolvers, we also have amiable facilities at our expense at NCIA. So with that, I know there'll be questions that will be coming, and we will interact more. So thank you very much for now. I take it back to the moderator. Thank you, Mr. Kiara.
Thank you very much, David. I forgot to mention that David is also part of the faculty at Nairobi Center for International Arbitration, and one of the mandates of the center is to train in ADR. Now, as we move on to the next speaker, I would want to tell the participants, if you have any question, you can go to the Q&A section, type your question there. I see already there is one or two questions. Type your question there. At the end, we are going to respond to your questions or your comments. Now, Lawrence, we go to the next speaker. Lawrence, as I had said, is the registrar of the Nairobi Center for International Arbitration. Lawrence, I want you to tell us about the origin of the center and what really is the mandate of the center, and probably how long you have been around, and maybe you could tell us about, are there any disputes that have been managed by the institution to date? Welcome.
Thank you very much, James. Thank you for your earlier introduction. All protocols of virtual greetings observed. Good morning, good afternoon, good evening from wherever you are. We are pleased to see many of you join for this session of LSK NCIA discussion on arbitration and ADR. David has alluded to a bit of what I would be sharing, but to return to the question by the chair, where did NCIA come from? What are the origins of NCIA? Let me share with you on the screen a little bit of information that will help respond to your question. So as I pull up the screen, let me first begin by mentioning that NCIA is part of what you'd call the Arbitration Adr Ecosystem. For arbitration or any other means of alternative dispute resolution to be efficacious, there are certain elements that need to be in place, one of which is a legal framework. The other one is what you might regard as the institutional framework. And then thirdly is the profession, the arbitrators, the mediators, the adjudicators, and the other forms of ADR, as David has so ably explained to us. So NCIA was an idea in the coming from the 1970s. Discussions involving the Asia-Africa Legal Consultative Organization were held. These discussions came up with a proposal to have regional centers in Asia and Africa. Nairobi was identified as one of those jurisdictions that would develop an institution for international arbitration, and I'll explain what that means shortly. And therefore, since those discussions in the 1970s, we now can speak about a center in Kuala Lumpur, a center in Cairo, a center in Lagos, a center in Tehran, and now in Nairobi. Now, of course, with time, the idea has been polished. It has been developed to the point where in the year 2013, an act of parliament, the Nairobi Center for International Arbitration Act number 26 of 2013 was passed. The main mandate of the center being the development of international commercial arbitration and other domestic alternative dispute resolution mechanisms in Kenya. From the name, you would see there is Nairobi. That speaks to the geography. The center is located in Nairobi, Kenya. It is a borrowing from the way in which centers similar to NCIA are named. So you will hear of the Singapore Center for International Arbitration. You would hear of the London Center for International Arbitration. And so Nairobi stands for the nomenclature that we normally use for this kind of centers. Then there is international. And that brings in the aspect of not just attending to the domestic or local market for arbitration and ADR, but going beyond the boundaries of Kenya and extending this service in the region and beyond to the international jurisdictions. As you will well understand, arbitration, when conducted domestically, need not have a complex structure that allows for people in different jurisdictions to practice in the domestic market. But when it goes beyond boundaries, there needs to be a framework which allows for instance, a commercial entity in Kenya, which has entered into an agreement with a commercial entity in Indonesia to have a framework which allows for them to arbitrate their dispute. And so given the structure that was developed with the New York Convention or in arbitration, it now allows for an institution of this kind to be located anywhere on the globe and be able to offer services to parties irrespective of their geographical location. Since its formation, the center has so far been able to develop rules for arbitration, mediation, and now moving to adjudication. As you can see on the screen, in the year 2018, 2019, the case value stood at 2.5 billion, which is equivalent to USD 25 million. In the year 2019, 2020, the case value increased up to 7.5 billion. That's equivalent to 70 million USD. And last year, the case value rose again, despite the challenges we have with the pandemic, to a value of 13 billion, which is equivalent to USD 130 million. You might want to ask, which are these cases? Where do they come from? So in terms of the type of cases, the nature of the cases, we have a broad spectrum of cases from suppliers contracts to energy-related contracts to employment contracts, and these traverse jurisdictions. In terms of the engagement of NCIA with other jurisdictions, as you see on the screen, the center has been, in the last couple of years, 5 years, engaged in promoting Nairobi and Kenya itself as a jurisdiction, as a seat for arbitration. And in one survey, which was done last year by SOAS University, UK, the center was ranked amongst the top 5 best arbitral centers in Africa. That's regarding the quality of support facilities and its administrative staff. It was also ranked 8th among the top 10 arbitral centers in Africa, based on the number of arbitral cases administered and the MOUs concluded with other arbitration centers. At the same time, it was ranked the top 5 among the top 5 arbitral centers in Africa that users indicated they would recommend to persons who are looking to access institutional arbitration. And then also in that survey, we were ranked among the top 5 arbitral centers with the best support facilities as chosen by the respondents. The others, of course, were IFSA of South Africa, the Cairo Center, which I've mentioned, the Lagos Center, and the CCJA of the Francophone countries. So in the 5 years we have been in operation, to answer your question, moderator, you can see the case load has been growing, including last year, which was a challenging year to conduct our services. And not only that, we've also grown to attend to the promotion of Nairobi as a viable seat for arbitration. There is also collaboration with other centers to allow for parties on the continent to access specific arbitration needs that are unique to contracts, especially of parties with commercial contracts on the continent and dealing with China. Admittedly, the volume of trade between countries on the continent and China has grown, and therefore a group of centers, both in China and on the continent, Nairobi Center itself being one of them, have developed what we call the China-Africa Joint Arbitration Center framework. The idea is to have eventually centers located in different regions of Africa and China through an agreed framework whereby parties can access what is akin to administered arbitration, but with sensitivities to the specific needs of China and countries in Africa. Where does that leave the other framework? This does not supplant or in any way remove the services that we render of arbitration, both domestically and internationally, but just to provide a specific special purpose vehicle for contracts that are China-Africa based. The structure that is already in place that deals with disputes of all kinds allows for us to administer, I think David mentioned this, arbitrations, mediations, whether they are domestic or international. So we have the Nairobi Center for International Arbitration Mediation Rules and the Arbitration Rules, which allow for parties to have a predictable, reliable procedure. One, for selecting clauses. Two, when disputes do actually mature, to request the center to register their cases, and then from that point on to appoint the arbitrator to manage the dispute all the way up to the delivery of the award, which is typically what is referred to as administered arbitration. Alongside this, we have a set of other rules that allow for us to make it easier for parties to access our administered services, and that would include the simplified user guidelines. It include the code of conduct both for arbitrators and mediators, and then of course practice guidelines to especially cater for the need of practitioners in terms of they being able to conduct the cases of their parties more efficiently. Now, the arbitration rules in particular will enable arbitration of both domestic and international disputes. Similarly, mediation would allow for the conduct of both mediation and arbitration disputes that are either domestic or international. Within the rules, if I could briefly mention, there are certain unique features. So for instance, parties are allowed to exercise the principle of party autonomy. They nominate the tribunal. What the center does is actually then appoint the members who eventually are agreed. That means parties are not tied to the list of arbitrators or mediators that NCIA have, but they have that list at their disposal. At the same time, they using the rules can determine the language, they can determine the seat. There are certain things which are already predetermined, the costs, there's a schedule for the fees for the arbitrator, a cost for the administration of the dispute. For arbitration in particular, there's a timeline for delivery of the award. For mediation, there's a timeline within which a mediation must be concluded. And what NCIA then offers is a neutral venue, whereby this network of participants in either an arbitration or mediation get administrative support. A case counsel is assigned to each dispute that we register. And so from the moment your case is registered with us, you have particular special attention to that case through the case counsel. All directions, all orders or communication from the parties to the tribunal are channeled through the avenue of the center. I can, for instance, mention one thing, seeing that some of you are counsel, and some of you might actually also be arbitrators or mediators. One of the ethos of either mediation of arbitration or arbitration is neutrality. And parties sometimes struggle with the aspect of, especially in the ad hoc arbitrations, the arbitrator also being put to the task of requesting for fees, writing to the parties to pay his fees. And sometimes you as counsel may be aware of what that means in terms of procedure, but your parties may not be. Now that is one burden we have taken away from the process. We are the ones who will communicate between the arbitrator and the parties regarding issues, for instance, like fees. There will be questions about documents and filing of documents. The arbitrator will issue directives. Those directives will be channeled through the avenue of the center with the case counsel to the parties, which therefore removes the direct involvement of the tribunal and allocates that task to the center, thereby allowing, fashioning the principle of neutrality before the parties, so that then the process is insulated from what in theory may not be actual intrusion, but in practice sometimes can be perceived as intrusion to the process, which affects neutrality. And similarly, mediation. In addition to that, we also have a statutory power of appointment. So you will notice that in particular acts of parliament, NCIA has been given power to appoint arbitrators. This includes the Nairobi Financial International Center. The other one is the Post Bank, the Kenya Airports Authority, and the Kenya Ports Authority. What do I mean by that? Whenever there is a dispute that requires arbitration under the framework of these acts, normally disputes regarding parties who have accessed either the port or the airport and their claims of a kind against the authority involved or the post bank, then the designated appointing authority is the Registrar of the Nairobi Center for International Arbitration. Now, if you practice in Kenya in particular, then it will be of significance to you as a counsel to want to engage with the framework of this act and also the NCIA to see ways in which you can better serve your clients in accessing the appointment services. Given that we are designed to offer special services, we have taken keynote of the specific needs of parties. So for instance, the timelines within which these appointments are to be made, the specialty of the parties of the dispute, and therefore the practitioners that are apt to handle disputes under these acts. And so what you end up getting is the background checks are already done by the center, so that by the time the parties have nominees to appoint in the arbitrations, a lot of the work has already been done for you. The Nairobi International Financial Center, which is a new creation that is still under development, but certain disputes also there eventually, where parties default, end up with appointment at the center. Let me also mention briefly about the panel list. For us to be able to offer effective appointment services, we maintain a list of arbitrators and mediators. I mentioned that we do have standards for appointment into this list that ensures competency. It also ensures that they meet certain standards of integrity. It also sifts issues about specialty of practice and assigns the individual practitioner either on the arbitration panel or the mediation panel. What this allows is that we have a list that is continuously being updated. We have persons on this panel that you, the council, and your parties can access, either at request or at the point where there is the rule of default, where the center will appoint in case one of the parties or both parties default in appointment of the tribunal. A thorough process of vetting is undertaken by 2 committees of the board, so that eventually, at the time when we confer a person the title, if you so like, of an accredited arbitrator or mediator on our panel, we have applied this standard to each and every individual. And then, so that I return it to the moderator, we also offer auxiliary services in the nature of training in arbitration, mediation. Already there is a curriculum that is running. There are modular courses, but which have already started. Coming week, another cohort of the module on arbitration will begin. And these services are meant to develop the capacity, both of you, counsel, and practitioners, to better provide services of arbitration and mediation. And then, as David also, of course, had mentioned, is a dedicated Adr Center. So at the NCIA, we do have on offer hearing rooms, training rooms, mediation rooms complete with caucus rooms. We are located at the Cooperative Bank House, Haile Selassie in Nairobi, and these rooms are offered at your convenience online. The booking is done online. You provide the details of your need and the dates which you need to access these services. We have offered these facilities not just to parties locally in Nairobi, but through MOUs with other centers outside of Nairobi, outside of Kenya. For instance, the Permanent Court of Arbitration. There are cases which have been handled under the LCIA rules here in Nairobi, hosted at the center. So for those parties who are in a particular case are not utilizing our rules, they still are able to access our facilities, and that's part of what the MOU with LSK now ensures members of LSK can also access. So back to you, moderator. That is in brief NCIA.
Thank you very much, Lawrence. Maybe, Lawrence, before I let you go, we had said that we can react to some of the questions at the end of the presentation, but some of them are, there are some questions which have been raised, and I think maybe 1 or 2 of them you have already addressed them, but we can just clarify that. We have on board, there is Jane Dungu, who asks, he requests that, he asks, how does one apply for training to become an arbitrator? So, I mean, how does he go about it? Of course, you have said you do training. Will you certify the arbitrators? Do your arbitrators get certified? And how does one go along getting that training? Together with that question, you can just, similar to one by Teresia Menia, who asked the same question about the training. There's a lot of interest about training. And she says that she has noticed their modules. Maybe you can just break it down briefly.
Thank you. And thank you, Ndungu. If I can begin with your question, you'd want to know how to apply for the training and become a certified arbitrator, which also seems to be connected to the question asked by Teresia. How is the training conducted? And the fact that you notice, yes, there are modules. Yes, I said one of the mandates that the center has is not only to offer the administered services, the actual procedure for arbitration supported, but also to offer auxiliary services, those that go a long way in supporting an efficient system. And one of them is training. So after a careful 2-year process, we developed what we now regard as our training curriculum, which covers both arbitration and mediation. Within this training, we deliberately have developed a path by which participants in the training taken through the basics of ADR, the basics of arbitration, the basics of mediation, and then grown through the path, through the modular process, module 1, module 2, module 3, that for instance, for the arbitration trainee would be taken through the various aspects of, so for instance, law of the obligations, the law of contracts, arbitration itself, the arbitration law. In particular, we'll emphasize the Arbitration Act of Kenya, the arbitration process itself, and the NCIA rules will form a basis to the bulk of this training. And then eventually, by the time they're getting to module, to the end of module 2 and module 3, there's the actual practice of the arbitrator, including the award writing, which is ever so quintessential in the process of arbitration. Once the participant completes the process, and we have a competent panel that takes the facilitation of these trainings, then parties, the trainees are certified at every level. So at the introduction level, at the modular level, there's certification, but then at the end, there's the accreditation. So once one completes all the modules, they are accredited as trained by NCIA. With this certification, they would have a premium to be appointed as arbitrator, mediator in any jurisdiction, by any center, and competent enough to offer these services as would any other person trained by any other institution, for instance, the Chartered Institute of Arbitrators. We have benchmarked the curriculum on some of the best, not just locally, but also globally, to ensure that at the end, we have a watermark to the certificate that we offer.
Thank you, Lawrence. The last question to you at this stage is from Joseph Nsomba. I think you had touched on it, but you can just clarify to him. He's asking, why call it Nairobi? Can it be changed to Kenya? Yeah. I know you joined the institution when there was already a statute in that name, but please say something to Joseph.
Thank you, Joseph. I would have been surprised if the webinar ends without that question coming. For every trade and practice, there is often particular usage that develops. Now, an arbitration is not an island in that regard. Arbitration began through what we used to refer to as guilds. This is a practice that began in the US. Those people who are trading in cotton would require speedy processes where their disputes are resolved by people who understand the cotton industry. They did not have to go to court. As the practice developed, so you'd have a cotton guild, you'd have a tea guild, you'd have a coffee guild. Eventually, the practice itself became identifiable with a location, a city. So for instance, London or New York and the rest. That practice was carried on in the mid-century when London Center for International Arbitration, for instance, was formed to handle the international aspect of the chartered arbitration then. And with that developed a practice of naming centers for international arbitration. So you will find there's London Center for International Arbitration, there's Nairobi Center for International Arbitration. What that does is that it helps the practitioner especially have in their understanding of, or especially the seat of arbitration, where what law would govern by default is. So for one who is in this practice, they will know if it is Nairobi Center for International Arbitration. Likely, all things standard, the default seat of arbitration will be Kenya. And if it is Kenya, therefore, they would want to understand the arbitration law of Kenya. As I have, of course, mentioned, that is just a default seat. Parties are free to select their seat. It could be, for instance, Kampala, which makes it Uganda and the rest. So the name Nairobi is only following in a long practice, which meant that we did not want to reinvent the wheel. But of course, it accommodates the fact that it is in Kenya. There's, of course, the element international, which then broadens the jurisdiction of the center's services.
Thank you very much, Lawrence. I think we move on to the next speaker, who is the final speaker, that is Jacqueline. If members, you recall in the beginning when we started this webinar, David did talk about arbitration clauses generally and the process of arbitration. Now, Jackie has been an arbitrator for a long time, and she's been an ADR practitioner for a long time. And I'm aware she's also worked in the corporate world. Now, what I'm requesting Jackie to do for us is to guide us on how to draft effective arbitration clauses. I know a majority of our viewers today, listeners today, are members of the Law Society of Kenya, and I think this would be very helpful for particularly those who have not interacted much or have not had formal training in arbitration. Jackie can be able to guide us on how to draft these clauses and make them part of a contract. Jackie, welcome.
Thank you, James. Thank you for the introduction as well at the beginning. And thank you to every one of you who has joined us this morning, this afternoon, wherever you are. Really just to place the conversation that both David and Lawrence, who have spoken before me, in some context from a more perhaps specific point of view in terms of the arbitration agreement. So I am aware that many of you are legal practitioners. It would have been useful to know how many of you are actually legal practitioners. I'm aware also that some of you are dispute resolution practitioners. So a lot of what I'm going to say, you may have encountered either in practice or in the course of your training, either in your university training or in your postgraduate training, specifically also in your training as dispute resolvers. So allow me to start off by reminding us about the spectrum or continuum of dispute resolution. So many times people talk about this continuum as if it's hierarchical. So we'll talk about negotiation, we'll talk about mediation or conciliation, we'll talk about arbitration, adjudication, and then at the tail end of that conversation, we'll talk about litigation. So what I really want to emphasize as I start is that this continuum doesn't really rank dispute resolution mechanisms in order of the most effective. It really specifies or perhaps elaborates the ceding of control along that continuum. So you will recall that when David Njoroge began this conversation this afternoon, he spoke about the party autonomy. So when we talk about that continuum, what we are really saying is at each level of dispute resolution, at each type of dispute resolution mechanism, what is the control that the parties have in terms of resolving their dispute? So if we're talking about negotiation, for example, and many of you will either have drafted or witnessed these commercial contracts. And in the contract, typically, unfortunately, this clause, this dispute resolution clause, if you have a 50 clause contract, the dispute resolution clause will be number 49. And it'll be the clause that you draft when you're fatigued, you've gone back and forth in terms of your negotiation with your counterpart, and you're just throwing in this clause at the last minute to close and sign. Sometimes referred to as the midnight clause for that very reason, because it's the clause we draft at the very end. So I want to encourage you today, even if it is the final clause that you're drafting, to give it a lot of attention, and we'll discuss why these clauses are significant in the course of my 20 or so minute presentation. So when you have a dispute resolution clause, I've already talked about the continuum. So essentially, negotiation gives parties more autonomy in terms of how they resolve their dispute. And as we move along that continuum, we'll typically head towards mediation or conciliation, where, as David mentioned earlier, you're bringing a third party neutral to facilitate your negotiation, not necessarily to give you a solution, but to help you work towards that solution. Moving further along that continuum, then we'll talk about arbitration adjudication. This is where you refer your dispute to a third party with the intention that third party neutral will give you a decision. So you can see already the party autonomy is a little less in terms of the outcome of that process. And then finally, litigation. And as you know, there, the judge has the final say. So when we talk about that continuum, a lot of people talk about it as if negotiation is at the one end and then litigation is at the other end. But there's also, if you are to extrapolate it, and I say this very often in all my presentations, you can actually decide to ignore the fact that you have a dispute even before you go to negotiation. You can just bury your head in the sand and forget you have a dispute or pretend that it doesn't exist. Not particularly helpful. At the outside of that, after litigation, you may decide to go to war. Again, not very helpful. So all that continuum is guiding your minds to is just the party autonomy at each stage of dispute resolution mechanisms. So with that in mind, and with that as the basis of our conversation, then a dispute resolution clause is really an agreement between the parties as to how they want their disputes governed. And they may very well start off by going along that continuum and saying, we'll use our best effort negotiations. If those negotiations fail within a specified time, we'll head to mediation or conciliation, as the case may be, especially if it's a labor dispute. You'll typically see conciliation being mentioned because that is the language of the employment statutes in this country. Beyond that, people may decide, we want to try arbitration, or if all else fails, we'll go to court. The skill of writing a dispute resolution clause is very much the skill of drafting a contract. So you want to be as succinct as you can be, as detailed as you can be, without going into a level of verbosity that then creates ambiguity or creates uncertainty. So at the heart of a dispute resolution clause is the fact that in addition to the party autonomy, you really want it to be clear what will happen in the event of a dispute. So think of it as, for those of you who are married or heading in that direction, your wedding planning. When you're planning a wedding, you don't think about the divorce. You should, but you don't. So this is the divorce planning within the wedding planning. And it is important so that you understand and you start to direct your mind to what will happen in the event of a dispute. And you're very clear so that there's no delay, because once a dispute happens, people typically want it resolved as efficiently as possible and without further cost, because typically somebody will be suffering and the other party will probably be enjoying a benefit in the other party's mind. And therefore there needs to be some closure to that process. So once you start to sit down and draft this agreement, what are the things that you need to be thinking through? And what is the significance then of a dispute resolution clause? Well, first and foremost, as David already mentioned, our constitution in this country encourages the promotion of alternative forms of dispute resolution to the extent that they are not repugnant to our sense of moral justice. So already the courts have directed their minds towards alternatives. And why is this? Perhaps to control the number of cases going to court, and we've seen this even with the development of the small claims court, to control the types of disputes that are going to court. Those of you who are mediators or who have trained in mediation are familiar with the fact that when mediation was first introduced as a court annex project, it was specific to commercial and family divisions, but has then moved on to other divisions. Also to control our behavior as counsel in terms of how we manage our clients' expectations, managing our own expectations as we're helping our clients resolve disputes. So ultimately, as counsel, you want to help your parties resolve their disputes. That should be at the forefront of your mind, even as you either are party to a dispute or as you are drafting these dispute resolution clauses. So the significance of the dispute resolution clause, to the extent that it is valid and enforceable, is that it then obviates the need to go to court unless and until that becomes necessary, and I'll explain that a little later. So when we're drafting these dispute resolution clauses, there are certain things we need, or certain features we need to consider. First and foremost is really around the appointment mechanism. So if we've put in that negotiation, and if it fails, then we'll move to mediation or arbitration or whichever other dispute resolution mechanism as the case may be. How will that third party mutual, if any, be appointed? Who will be the appointing authority? Now, typically what you see, at least in this jurisdiction, is we will defer where there's a failure in agreement between the parties, we will defer to a professional body to help us appoint a third party mutual. Some of these professional bodies are the Law Society of Kenya, the Chartered Institute of Arbitrators, the Engineers Board, BORAC, and of course the Architectural Association of Kenya. And with the understanding that, and this was alluded to by Lawrence, that these institutions or centers maintain their panel of third-party neutrals, and they have a criteria. And I saw a question, I think, about how once you are qualified as a third-party neutral, how you can then get appointed. So really, first is to make sure that you are empaneled to these panels, whether it's the Law Society or any other professional body, including NCIA, and that empanelment has its own criteria for each and every one of these institutions. And indeed, these institutions may also call upon you to update your CV every so often, update your profile on their websites every so often, so that you're keeping current with your own qualifications, and they are keeping current with knowing what's going on with you, what are your areas of interest. You may, for example, not wish to be appointed as a commercial arbitrator. Maybe your focus is on family mediation, and that's where you want your focus to be. Let the institution know, so that as they're looking at their panel and they have a dispute before them, then they know that this person has X number of years of post-qualification experience. This is the kind of focus area that they focus on. This perhaps is their track record with us as an institution. So even as when you're appointed as a third-party neutral, please close your matters as professionally as possible. And this means that you will keep the institution apprised of your progress even after you're appointed. These are the matters you've referred to me as a third-party neutral, and this is the stage at which we are with each of these matters. That was a slight digression. Let me go back then to the dispute resolution clauses and the drafting of those. So as I've mentioned, the appointing mechanism, very important, because a failure in the appointment mechanism could very well be a failure in the clause in total. Which rules of arbitration or mediation, or as the case may be, or adjudication as the case may be, you may, for example, say we want to defer, and Lawrence already mentioned this, we want to select the NCI rules, and those will apply to our dispute resolution process, which is the governing law, and this is the substantive law, so what we call the juridical seat. In our case, for example, if it's an arbitration in Kenya, then the governing law will be the Arbitration Act of 1995. And to my mind, currently, and at least unless and until there are developments in the Senate, we don't have any other substantive jurisdiction on specific areas of dispute resolution. And by that, I mean arbitration is governed by the Arbitration Act 1995, and Mediation is largely driven by procedural rules of different institutions, whether it's the Nairobi Center, the Chartered Institute, Strathmore Dispute Resolution Center. All these institutions have their own rules in terms of appointment, the procedure, what timelines they ascribe to, that sort of thing. So when I said that we have to be detailed without being verbose, then one of the things we have to consider, and I'd really like us to have some conversation around this, is it necessary, for example, to say in your dispute resolution clause that parties may still go to court and seek any interim measures that they need? Is it necessary, or is it something we just throw into dispute resolution clauses because we've seen it in other commercial agreements? Is it sufficient that substantive law, for example, the Arbitration Act 1995, empowers parties under Section 5, Section 6 to still seek interim measures under the protection of the court, even as these alternative forms of dispute resolution are being pursued? So do we need these types of clauses, these types of mentions in our dispute resolution clauses, or is it something we just do blindly without necessarily thinking through what the import of those mentions are? Do we also have to say that an arbitration will be final? And I know I'm opening up a can of worms in view of recent decisions of the Supreme Court, but do we have to say that arbitration will be final? Is it sufficient, for example, to rely on the provisions of the Arbitration Act 1995? So like I said, I want us to have some debate around some of these issues, because many of you are practitioners and many of you are experiencing this on a day-to-day in terms of some of the matters that are either before an arbitrator or have been sent to mediation. The other thing in terms of the dispute resolution clauses that I typically see are a whole conversation around costs and which party will bear the costs. Typically, again, what I have seen there is that each party will bear their own costs. However, in this jurisdiction, we know, and it is very trite law, that costs follow the event. So is it necessary to say something about costs in the dispute resolution clause, or is it something we want to leave either to the parties at the tail end of their process, whatever that dispute resolution process is, or indeed to existing statute or established law on how costs will be treated? So as to jurisdiction, it's also important in that appointing mechanism to state which disputes arising out of that commercial contract will be subject to an alternative dispute resolution process. Is it all disputes arising out of that contract, or is it disputes arising out of specific clauses of that contract? Again, it's for the parties to decide, and it is really for you as the counsel informing those parties and advising those parties to determine whether it is indeed all disputes or disputes arising out of specific clauses of the underlying commercial contract. As David mentioned earlier, your dispute resolution clause is the arbitration agreement or the mediation agreement or the adjudication agreement. So it is essentially that party autonomy being expressed insofar as how you want your disputes resolved in the event that they arise. A lot of times the question arises then, if your commercial contract doesn't have that dispute resolution clause, can you still refer your dispute to a system outside of the court system? And the short answer is yes. Because even after the dispute has arisen, you can enter into an ad hoc agreement. An ad hoc in this sense simply means it is not contained within the commercial contract, the underlying commercial contract, but it is arising out of that contract. And therefore, any dispute arising, or indeed specific disputes arising out of that contract, will be referred to a third party neutral to help you determine your dispute. Once the decision is rendered, whether it is in the form of a mediation settlement agreement or an arbitration award or an adjudication, then what is the import of that on the relationship between the parties? And this is where you get into the realm of enforcement. And if you go back to what I mentioned at the beginning about the continuum, enforcement will largely depend on the dispute resolution process that you have selected. So if it was a negotiation, then it's assumed that people have shaken hands and they have signed on it in terms of a negotiation agreement arising out of that dispute resolution process. Similarly, with mediation, you will perhaps enter into a mediation settlement agreement, and it could be on all the issues or on some of the issues. It really just depends on how that process has run its course. In terms of an award, an arbitration award, it can be challenged if it does not deal sufficiently with the subject matter. And this is why an arbitration agreement is important in the context of a dispute resolution clause. If you have not dealt with all the issues as an arbitrator that have been placed before you, then you have not dealt with the award as a final award. There will still be a lingering issue, which may in fact impact any other issues that you have already determined in your award. So really important to think through what the dispute resolution mechanism is and which laws apply to that dispute resolution mechanism, if any, which procedural rules apply to that dispute resolution mechanism, how you are applying them in the context of your particular process, because rules will sometimes give you leeway in terms of choosing everything or choosing certain aspects or excluding certain aspects of those procedural rules to the extent that you are not then damaging the whole process, for lack of a better word. I want to stop there so that we can then have a conversation around some of the issues that I have raised and some of the debate that I hope I have elicited. So I will hand it over back to you, James, so that we can then continue the conversation. Thank you.
Thank you. Thank you very much, Jackie. Definitely, you have elicited some responses. We're going to get to them. But Jackie, before you react to the questions that are on the Q&A section, I would want you to kindly just say something about you're an advocate in practice here in Kenya, and you're an arbitrator. What happens when the dispute resolution clause is not drafted properly and then a dispute occurs? So that, because a majority of our listeners are advocates, so what is likely to happen? So please tell us.
So if the dispute resolution clause is not properly drafted, and I think I mentioned this a little earlier, then it raises another dispute around the enforceability of the dispute resolution clause. So you will first sort of have to determine that issue around the applicability of the dispute resolution clause before you even determine whether the matter can be referred, the underlying dispute can be referred to a dispute resolution process.
Yes, and the various institutions we've been talking about today, Jackie, that is the Nairobi Center for International Arbitration, the Chartered Institute of Arbitrators. Some of them have, these institutions do have standard arbitration clauses. What would you advise about these clauses as regards, and can one amend them to suit their needs?
I believe you can, in the spirit of party autonomy. You can decide which of those standard clauses will apply to your particular dispute resolution agreement and which of those you would want to exclude. So the short answer is yes, in the spirit of party autonomy, you can decide.
Okay, the last question I would want to engage you with, Jackie, is tell us what considerations you would take, what considerations you would consider when you are drafting the clause, an arbitration clause for a three-member tribunal or a single arbitrator. Some clauses have a single arbitrator to determine the dispute, while others have a panel or a tribunal of three. What would be your considerations in choosing either?
I think the overarching consideration would be, firstly, if the parties have a view one way or the other on how to maintain the neutrality of the third party neutral. If they feel one sole arbitrator can do it, then fine. But if they feel that they each want to appoint one and then those two arbitrators appoint a third, just to further propagate that neutrality, then that is also fine. Obviously cognizant of the costs that will be attached to having more than one third party neutral. A lot of our institutional rules, and I'm sure Lawrence can further elucidate the NCI rules specifically, will give you that mechanism. And indeed, Section 12 of our own 1995 Act also goes into a lot of detail into the whole process of appointment of an arbitrator, specifically when we're talking about arbitration. In mediation, it's a little more clumsy than one mediator. for the simple reason that the mediator does a lot of work in terms of building rapport with the parties, in terms of having their own sense of which direction the mediation is heading and how they want to then handle any impasse or any deadlock. So I find it clumsy to have more than one mediator, especially when the matters can be dispensed with, a little more efficiently. But again, that might elicit some more debate among our participants this afternoon.
Okay, Jackie, the very last question, because it is directed specifically to you by one Gloria Kuyo. She asks, does any of the speakers, Jackie specifically, offer mentorship opportunities to those willing to pursue the career? Please give Gloria an appropriate answer.
If your head is on as a mentee, and then this is interesting. I'm sure you've also experienced it, where a mentee is assigned to you and then they disappear. So, if the mentee is willing, we are very willing to mentor, myself included. But it is a big if.
Yes, and maybe we would add to Gloria, other than the mentorship, of course, we would have to first undertake some training in arbitration, probably at the Nairobi Center for International Arbitration or at the Chartered Institute. Then you move on to the second level, which would be mentorship. Now we have a couple of, so we have dealt with a number of questions that have been coming on the board in the Q&A section, but there are some that are still left behind, and I think we can go straight to those questions. I would probably start with Lawrence. Lawrence, there is a question by an anonymous attendee who says, why are the modules very expensive? Perhaps a subsidized rate would do. Also for the modules, must one begin from module 1? LSK members, as I assume, have the basic knowledge of the course content. At least as we get along this webinar, we have participants who are on your website and they're seeking information there and answers from you now. Lawrence.
Okay, thank you, James. Let me begin with the second part of the question. Must one begin module 1, especially if one is a member of LSK? The curriculum is so designed that at least the introduction, which is a beginning, those who have qualification in law, for instance, members of LSK, would get an exemption from the introductory course. Module 1, on the other hand, is different because some of the course content is not only just the elements of law that are dealt with, but is specifically designed with arbitration or mediation in mind. So if you are like me and many of us who might be listening this afternoon, whereas we did go through law school, and that includes a university, and did courses in law, very little of it was tied specifically to address the question of arbitration and ADR. So that when you look at the content, although it may talk about a subject you probably would be familiar with, there's if you want so to call it, the adds-on, which specifically focus the content to prepare you for module 2 and module 3 with regards to arbitration and mediation. So it will not be time wasted. It will actually be time gained when you see the theoretical bit of the law being applied to arbitration or mediation. So that may be one of the answers I could give. On the question of why is it very expensive, maybe I may want to mention, if for instance you look at the costs of the courses we are offering currently on our calendar, virtual training, we have taken into account that this is being conducted on the virtual platform, and the rates in terms of the virtual training have significantly been subsidized to remove the overhead costs that would obviously be associated with in-person training. So already we have consider that and factored it into the pricing. If it is a generalized view that the cost would be expensive, let me allay your fears by mentioning a couple of things. One, we have a thoroughly competent faculty that is dispensing the program. Secondly, we have ensured that our costing is literally almost to ensure that we meet the costs of delivering the course content. We would even go further to want to offer this cost at perhaps just to meet our costs. But obviously, for us to continue to develop a world-class curriculum that can compete fairly, that assures you that you have a watermark at the end when you're certified, there is a cost to it. And what we have ensured is that we have maintained the bare minimum costs that would allow us to offer you a course content that is comparable to perhaps none in the coming future.
Okay. Thank you, Lawrence. We have another question by one of the participants who asks, are there any links between NCIA and government? Because in some government contracts, the seat of arbitration is not with NCIA. Please speak to how power plays also affect the seat of arbitration, especially in international contracts, and how can the seemingly weaker party navigate to ensure they get a better deal, because a party in Kenya choosing New York, for example, is very costly. Lawrence?
Okay. Let me go back to something Jackie mentioned.
Please.
The crafting of an arbitration clause must include both the honeymoon and the divorce. Preparation for both the honeymoon and the divorce. When parties enter into agreements, contracts, whether local or international, at that particular time, obviously, what is in mind is a financial economic benefit that the contract is likely to confer on either of the parties, whether they're two, multiple, and the like. Now, because they're also aware that disputes will follow agreements, they then provide for a clause that allows for them to resolve their disputes by the preferred mechanism. A center like we are is really a neutral party. We form the third axis of the triangle in the event that parties will have a dispute. So we are not stakeholders in the sense of the eventual outcome of the resolution of the dispute. The only interest we have in the dispute is to see that the process is managed and the parties live with the product they expect at the end, which is an award, and to ensure that the award they have is enforceable. Now, who actually arbitrates, for instance, if it is arbitration? The center, even at the point of appointment, only will determine the tribunal members as a default mechanism. So first, the first instance is the parties themselves who will nominate the arbitrator. If there are three arbitrators, each party will nominate their arbitrator. Those two arbitrators in most instances will appoint the chair of the tribunal. And what remains for the institution, that's NCIA, to do is to manage, to administer the logistical aspects of the disputes. That way, if the question is, does NCIA have any particular inclination to either of the parties, you realize that the default mechanism already removes NCIA from a stake in the actual outcome of the dispute. These nominated arbitrators eventually will hear the dispute, they will consider the evidence, they will write an award, and that award eventually will be handed back to the parties. NCIA has not played a decisional role. So irrespective of whether the party is the government of Kenya or a private party, the NCIA has only been involved in that case purely as a conveyor belt who is a specialist in offering an administrative and management process, which actually is an add-on both to the parties and to the tribunal. So, that's one element. Will there be contracts, for instance, that involve government of Kenya where NCIA is not the center? Very likely, because just like in any other contract, I am sure both parties will have exercised their mind into the choice. There will be considerations that they give thought to prefer one location as opposed to the other. However, it should also not be a surprise where a contract where the government is a party includes NCIA, because then I believe both parties or the multiple parties involved will have also answered the questions necessary to settle on a particular center. Finally, moderator, this is not unique. I would mention, for instance, LCI, which is the London Center for International Arbitration. The UK government, like any other government, has specifically given guidelines, circular to its institutions, that the first preference when it comes to selection of a center for arbitration in contracts involving agencies of the UK, of the Her Majesty's government, is LCIA. Now, what they are not saying by such a guideline is that NCIA necessarily will favor. In fact, it cannot, because it doesn't determine the dispute. And so similarly, there should be no reason why the government of Kenya, or any other party for that instance, should not be at liberty to appoint NCIA as a center in its agreements, knowing very well that at the end of the day, NCIA, in terms of the decisional aspect of the arbitration, has absolutely zero role other than to administer the dispute.
Thank you very much, Lawrence. I'll probably come to you after a few minutes. Maybe David. David, are you with? Can you hear me? David.
Yes, I can hear you.
David, there is a question by Teresia Memia again, and what she asks is that are agreements drafted by advocates, in agreements drafted by advocates, a clause providing for arbitration, who pays the arbitrator? And should there be a period upon which it should be undertaken? I think that last part, I'm not sure whether she means, is there a period within when the payment should be made, or does she mean whether the duration for the arbitration? You can still respond to both.
Okay.
Thank you.
Okay, thank you. Thank you for the question. I think, as Jackie put it, the art of crafting this arbitration clause, or the ADR clause, is very, very important, because it will be the start of the dispute. And you do not want to start the dispute with a dispute as to the interpretation of the dispute resolution clause. So it is very important to pay considerable time and effort to ensure that, one, the dispute resolution clause is quite clear and unambiguous, so that when it comes to the time when there is a dispute, then it can take effect automatically. Specifically to the question asked is about issues of payment. The dispute resolution clause, what you do normally is you say whenever there is a dispute, then it shall be resolved by way of arbitration. Then if it is by way of arbitration, you must also provide what is the mode of appointment of the arbitrator. We talked about party autonomy. So the first automatic way is parties to agree. Many a times you'll find that parties will not agree. Then provide for an alternative, a default clause that will provide that maybe a body, LSK, CIA, NCIA, to appoint the arbitral tribunal. So once the arbitral tribunal comes into place and it has the jurisdiction, after satisfying itself that the arbitration clause is quite clear and it closes diction, then issues of costs will be discussed there. And I differentiated this when I said, if it is ad hoc, then the arbitrator will lay out the terms of engagement and the parties will be expected put in a deposit, will give you the hourly rate of the arbitrator, and then the parties will be expected to pay. If it is an institutional based embargo of chasing you the parties to pay, and will be able to give the terms of reference of and the parties will pay to the center, then the center will pay the arbitral tribunal. I hope within that I have been.
Thank you, David. That is very. You have answered the question very well, and I hope the participant is satisfied with that answer. Now, Jacqueline, we have a question from Jacqueline. Jacqueline asks, Jackie, I have seen some contracts making reference to ADR in general. If there is a dispute, which form of ADR will be applied? In addition, how can one determine or help his or her client determine the most appropriate form of ADR for dispute resolution process in the contract?
Thank you, and thank you for that question, Jacqueline. So you're saying that there are contracts which have just referred to ADR in general. It seems to me then that is an ambiguous dispute resolution clause, to the extent that it does not identify which is the preferred means, if any, of dispute resolution, and also, as David has immediately just said, how the third-party mutual will be appointed. So there's no harm, and this applies also to the question, Janet Wakabi, that you have asked. There's no harm in entering into what we call a post-contract dispute resolution agreement, which then goes into a little more specifics of the dispute resolution process. So do the parties want to, in the case that you've indicated, Jacqueline, do the parties want to try negotiation and then move to another type of dispute resolution mechanism that includes a third-party mutual? If they do, how will that third-party mutual be appointed? And what period, within what timelines do they want these appointments to be made? And if there's failure between the parties to agree, do they want to refer then to an institution to make those decisions for them, so to speak, in terms of determining the rules that will apply to the dispute, and also, or rather the resolution of the dispute, and also the means by which that third-party mutual will be appointed. So it is perfectly in order to enter into a post-contractual dispute resolution agreement. I hope that answers that question. Thank you.
Yeah, thank you, Jackie. Related to that is a question by Faith Niba. And Faith asks, in the event parties are unable to agree on an arbitrator and they proceed to request either NCIA or the Chartered Institute of Arbitrators to appoint the arbitrator, who is expected to pay the relevant institute to enable them make the appointment? Is it the claimant or the respondent? Jackie, please.
Okay. Typically, the person who has immediately run to the institution to seek help will bear the cost. And at the point where a determination is being made, then the apportionment of those costs can be included as costs of the process and claimed as costs of whether it's arbitration or costs of the mediation, or indeed at the point of, if the other party is amenable, then at the point of referring to the institution, then they can split the cost 50-50. But typically what happens is the party who has sought the assistance of the institution will settle and then attempt to claim it later as costs of the whole process.
Yes, and maybe if you look at Faith's question a little bit, you'll note that she says when parties are unable to agree on an arbitrator and they proceed to request either NCIA, I believe, or the Chartered Institute, that procedure must be provided. Who is the appointing authority? Because it's entire clause, the one what you took us through earlier on. So I think Faith would need to look at the clause more and see what does that arbitration clause provide for. Does it provide for one party to? Does it provide for NCIA or the Chartered Institute to be the appointing authority? Yes, so I think you have answered Faith's question. We have three more questions. We have three more questions. One, and I note there is some of the participants are of course confusing the Nairobi Center for International Arbitration and the Chartered Institute of Arbitration. So I think there are two questions here. I think the participant may have confused the two, but we'll clarify again. Now, maybe Lawrence, you can, there's a question here that how do you ensure that the Center or Chartered Institute of Arbitrators does send us work? Definitely this is probably a lawyer. So of course I know that at the Chartered Institute of Arbitrators, you need to be a member, and of course to become a member you need to attend some courses. You become a member, and then you go through a mentorship program, which there is a mentorship program under the Chartered Institute of Arbitrators, and then only can you now be appointed to to sit as an arbitrator. But Lawrence, maybe you can add on to that and clarify about the center.
I hear you. That sounds to be a bread and butter question, and it must be treated as such. When I mentioned at the beginning, the case value and case load over the years has indicated a steady upward growth, so that we began somewhere in the whereabouts of 25 million, and now we are talking about a billion shillings in terms of value of disputes. And that's a value proposition for anyone considering engagement in arbitration. But how can you then access the work as an arbitrator, the work as a mediator? Obviously, there's an element of visibility, and that visibility can only come if you are, for instance, on the panel of arbitrators for NCIA. When we exercise the power of default appointment, where parties have disagreed or parties themselves prefer NCIA to appoint, we naturally will go or fall back to our panel of arbitrators. If one is on that panel, they stand the opportunity of being appointed to act as arbitrator in a tribunal, either sole arbitrator or the three arbitrators that may be appointed in an arbitration case. So my invitation to you in response would be to give us an email. We will send to you the particulars of our standard for arbitrators and mediators, depending on your interest. That standard will give you the criteria for qualification to be on the mediation or arbitration panel. We will work with you through the process of application, the process of ensuring that you provide the requirements that are needed to support the application. And then eventually, once it is evaluated and it meets the threshold, you find your way into either the arbitration or mediation panel of the center. So in respect to the international or domestic arbitration cases that would be flowing into the center, we have extended the panel's access now to what I refer to as a China-Africa Joint Arbitration Center mechanism, so that from our own panel of arbitrators and mediators, again, through this framework, with the standard that is applied in that framework, those that are already within our panel would be considered for empanelment on a China-Africa Joint Arbitration Center arbitration panel. So you see thereby you broaden your access to work, not just to the domestic market or the international market of NCIA, but also to the China-Africa Joint Arbitration Panel. And you could only see how the horizon expands. These disputes that I have mentioned have been handled by NCIA have been heard and awards delivered by practitioners like yourself, but they must make themselves visible by accessing the panels so that then we can, when parties request, for instance, I have seen this practice, statutory appointments, parties will request for names of people with specialty, and we have a fallback panel which, with all fairness, we will treat each name depending on qualification and the case before us, and give proposals to parties. That could be you, but then you have to be on the panel.
Thank you, Lawrence. One more question for you, Lawrence. And I think this is a question that in most of the ADR seminars or meetings that we attend, and specifically arbitration, this question is always coming up again and again. The question that is being asked is, ADR mechanisms ought to be affordable in comparison to litigation. However, the fees, especially the institution fees and the arbitrator's fees, makes it astronomically higher, making it less accessible. Is there a way to bridge this gap? Probably, Lawrence, you can start by telling us whether it is high or not, and then maybe we can go to the second part of that question. Then we'll go to the final question.
Okay, again, when you think about actual costs, research has been done that has shown that in the whole, the largest percentage of fees paid by parties by involving themselves in arbitration often will go to legal fees. Administration fees that are paid, for instance, to an institution, and auxiliary services that normally will accompany the hearing facilities, transcribers, and the rest, normally will account for about 2% to about 7%, and the rest is basically legal counsel fees. So let me begin off by saying it's good to break down the components so that you see where the actual costs go. How expensive or how much we spend on a particular case will depend on many factors. One of them is a question that had been asked earlier. How many members do you have in your tribunal? So if it is a case where there are 3 members in the tribunal, which could have ideally been handled by 1 member, that can affect the costs. When the matter itself is placed before the arbitral tribunal, how cooperative are the parties through the discovery process in insisting on interlocutory applications, in compliance with the directives or directions of the tribunal. Parties themselves can contribute to the actual costs of the process, so that the question whether it is expensive or not might require a little bit more conversation. Then if you're comparing it to litigation, have you considered the aspect of time? What are you giving up by going to litigation that you would have had in arbitration? You do not determine the tribunal. You do not determine when your case will be listed, how long it will take for it to be listed, when it shall be concluded. Most, I perceive, will be lawyers. We know how long it takes before any ordinary case is tracked to hearing and eventually a judgment is given. A judge might be transferred. That adds to the element of time and cost. So I think when one eventually actually does a cost-benefit analysis, you might actually find it actually isn't expensive. You can control the process. You can select the issues that are to be determined, and therefore reduce the cost even at the determination of issues themselves, which sometimes a mechanism is lost when you go to the courts. So I sitting here would say it depends on the factors that you're considering. But all factors remaining constant, parties managing the process as they should, the tribunal managing the process as it should, then I would say it appears that arbitration would be the way to go. I look at the cases that we have been handling, and on average, they're spending about 150 days on average to be concluded. this is a commercial contract. That's good for business. That's good for you as counsel. It's good for you as an arbitrator. As arbitrators, especially for administered arbitration, cases struck to the center, the rate of payment for arbitrator fees, from experience, what I have seen is that within 30 to 40 days, this is paid. Now compare it to ad hoc arbitration. You know what experience is out there. So to answer your question, it depends on what you want to buy.
Okay, thank you very much, Lawrence. I think members, our time is up. It is just a minute to 4 o'clock, and I would want to thank all the participants who joined us today, both locally from the Law Society of Kenya, and some of them had joined us internationally. And I also want to thank the Nairobi Center for International Arbitration very much for organizing this free seminar for members of the Law Society of Kenya and other stakeholders. And of course, I would also appreciate the speakers today, Lawrence, Jackie, and David, for making time to make their presentations. And of course, also answering indeed all the questions that have been asked. They either answered them virtually, and others, of course, they typed the answers. So thank you, members. I think I'll just hand over to back to the Institute, and maybe Lawrence, you can guide the participants if they have any queries. How do they interact with the center? Do you have an email, or how would they get further information? Because within these 2 hours, I believe there are others who still want some more information regarding the center. Thank you very much. Thank you very much, and God bless.
Allow me, Chair, to thank you on behalf of the panelists for your very able, well-spent time. Thank you, my co-panelists. It was a privilege to participate together with you in this webinar. I want to thank also the participants who have been with us from the beginning. I, in particular, want to acknowledge the LSK branches of Nairobi and Mombasa who have supported this webinar. We look forward to many more engagements with you. Now, I know there could be questions that were not fully answered. There could be others that were not asked. Please write to us at info@ncia.or.ke. You can also write to me, Registrar at NCIA, registrar@ncia.or.ke. I will type it out there for you. You could visit us on our Twitter page. You could also visit our website for materials on our services and what we offer. You could visit us at our location at the Cooperative Bank House, 8th floor, Nairobi. And very soon we shall be visiting the branches virtually, as we have done this afternoon. And so we hope to interact more with you, especially on the training. We already have a calendar that's on our website, on our Twitter handle. And of course, there will be further communication with you with regards to webinars, which will be running month by month in the coming season. Thank you for being with us, and thank you again, Chair, for hosting the panel.
Thank you very much. I think now this event, this seminar now has come to a close, and have a good day.
Thank you.
Thank you.
Bye.
Thank you. Bye.
Bye. Thank you.